She will be talking a little bit about how Bostock created the historic protection, LGBT protections in North Dakota. So I will give you the floor or the spotlight.
Okay, thank you so much, Alex. I'm going to try to share my screen here. Let's see. Can you see my screen, everyone? Okay, perfect. Wonderful. I will. Okay. There's so many things that I want to say before I jump into all of this. And I'm going to try to keep it streamlined and succinct, but mainly I just wanted to say a huge thank you to the organizers of this event and anyone who has had a part in the creation of this event in North Dakota, and for the people who have been trailblazers in North Dakota for LGBTQ plus rights and for the community at large for as long as I don't know, maybe time memoriam. And I really wanted to give a special thanks to Alex as the, I think, kind of main organizer behind the scenes. Thank you, Alex, for everything that you've done. And you put together just a really beautiful weekend of things. And thank you to Barry Nelson and the Human Rights Coalition and so many other people, just even for asking me to be a part of this, but more so for going forward with having this summit in the way that you're doing it. I really, really want to say thank you for making it in a digital form. I know that it takes away from the direct interaction that we have, but it's the safest choice that we have right now. And so I personally am very, very thankful for that. And I know that it's been talked about probably throughout this weekend, but I just wanted to say too, on that note, I think about the last month for myself. I became a first-time aunt. I had an uncle pass. All of these like life events happened in just such a short period, as the world goes on. And I got a little bit emotional thinking about it this morning, but I tried to reel it back in. So I'm going to try to not get too teary-eyed because I got to get to the Bostock here. Opinion. But I just want to say to this group that I'm with you in every way, because I can't even imagine all of the struggles that everyone was already experiencing pre-COVID-19, and all of the things that we have that give us happiness and joy and celebration and etc., that have either had to be on hold or done in a way that maybe isn't quite completely the way that we'd like them and satisfy our hearts exactly the same way. So I wanted to say that to all of you, and that I've just been so impressed with the LGBTQ plus community at large this summer, especially with everything that's been going on. I think redirecting to be allies of those who are struggling with the all types of civil unrest that are happening across the nation and the world at this point, and in North Dakota. And so anyway, I want to say thanks to everyone who's been a part of that. So with all that being said, just huge thank you again. And my name is Erica Thunder. I serve as the commissioner for North Dakota's Department of Labor and Human Rights. I've been in this role now since June 3rd of 2019, so about a year and 4 months-ish. It's an appointed role. I'm a member of Governor Burgum's cabinet, but one thing I like to note is that, at least with my role, I don't know, I'm assuming that their cabinet leaders had the same under this administration. It was not like, okay, we'll push this person into this role, appoint, sign some things, hooray type of thing. I had to apply like any other job. And in fact, it was probably the most intense application process that I had. There was a lot of vetting involved. Counting it all up, I think I had 7 total interviews, and the final one was with Governor Burgum, who at the time, and has continued on. I'm not trying to make any statements, by the way. I'm just trying to give a little background about maybe why I can be the way that I am, and also why I feel empowered to be the way that I am in this role specifically. In my conversation, in the interview, the final interview that I had, the main topic was, what are you going to do, Erica, if you were to be the Commissioner of Labor and Human Rights for the LGBTQ plus community? We've never had a successful bill passed for protections for sexual orientation or gender identity. Will you do this? And honestly, I guess I've said it so many times now publicly, but I already was planning to do that no matter what, if I was so chosen to get hired. And so I appreciated that, and I still appreciate that. I talked a little bit before this about the fact that hate crime legislation is something that I've been looking at, not only as the commissioner, but just within my agency and then outside of my agency too. And I've been very thankful to have been invited by these wonderful groups talking about what maybe some action plans are, both at the local level and at the state level. Obviously, I'm much more, I have a easier route looking at the state level. And I've had great conversations with fellow cabinet members who have already pledged their support behind anything that would come up. And that goes for the office of the governor too. They've been supportive. That's not a political thing of like, this is how great this is. I'm just saying that's how the conversations have gone, which for me has been helpful, because I just look at myself as a conduit really in this role for that. Bostock, maybe I'll go back just a little bit further to, for anyone who might not know about the Department of Labor and Human Rights, we are a neutral law enforcement agency, and we have 3 primary functions. We enforce the state's wage and hour laws. That's one of our divisions under labor. We also enforce our state's anti-discrimination laws and our whistleblower laws. Everything under human rights, housing, public service, public accommodation, et cetera. Thirdly, we have a statutory obligation to educate the public and do outreach. And then conversely, if we're being reached out to go to groups who want further education on anything from our employment laws in North Dakota to human rights laws, et cetera. So we're here whenever someone wants us to speak. Our agency is very lean, but the bulk of the agency is made up of our compliance investigators. And so if you ever were to or have filed a claim with our agency, most of the interaction that you have will be with an investigator that's assigned to a claim or case. I think importantly for this conversation, North Dakota enforces our agency enforces the North Dakota Human Rights Act. And that was fully enacted in 1996. And this establishes our protected classes in North Dakota, which aren't so very different from the federal protected classes, but it makes it illegal to discriminate against members of protected class, which I will get into quickly here before I finally get into Bostock. But it makes it illegal to discriminate against members of protected classes in employment, in housing, in public service, in public accommodations, and credit transactions. And there are only minor differences between the protections that North Dakota has and between our laws and the feds. Under federal law in all 50 states, the protected categories that make it illegal to discriminate based on are race, color, national origin, religion, sex, which the Bostock case encompasses, and that's what we'll be focusing on today. But outside of now what sex is also considered, sexual orientation and gender identity through the Bostock opinion, it includes pregnancy, childbirth, and related medical conditions. Disability is another protected class, age, 40 and above, citizenship status, and now genetic information. North Dakota basically has a very similar list. It also includes marital status, and that actually does not include, it includes what was traditionally known as marital status. So asking questions of if you're married in an interview, or basing certain conduct off of are you married in, again, this, I don't even want to say traditional sense, but between man and woman. That was the protection. It also, in North Dakota, covers lawful conduct outside of work, receiving public assistance, which might be news to some people, not anyone on this call, but maybe some other folks, keeping and bearing arms, and status as a volunteer emergency responder. Okay, I'm kind of keeping some of my thoughts close to the belt, but I don't need to. But anyway, so those are some of the protections. Now, Bostock was one more historic and landmark United States Supreme Court case. We've been very, very blessed to have a number throughout, specifically the last decade, I would say. And the opinion held by the court was that Title VII of the Civil Rights Act of 1964 protects employees against discrimination because of their sexual orientation or gender identity. And the petitioner, just to give a little bit of some of the facts behind the case, was a man by the name of Gerald Lynn Bostock. The respondent was Clay County, Georgia, whom he had been working for. He worked his way up through various courts, and inevitably a writ of certiorari was granted by the petition of Mr. Bostock by the Supreme Court in April of 2019. It was argued before the Supreme Court on October 8th, 2019. It was decided on June 15th, 2020, which is an extremely important date, not just because that was the day that this decision changed 26 states laws effectively, but more importantly for the actual tangible part of what we're speaking about. If someone were in a situation where they felt discriminated against and believed that they were because of their sexual orientation or gender identity, June 15th has now become the last date of harm. So when you think about that, if you're making a claim with our agency or the EEOC, Equal Employment Opportunity Commission, your date of last harm would have to be at least June 15th. We had a very tricky and inevitably sad situation where someone had filed with us just days before this opinion came out. And honestly, this opinion was a surprise. I don't know how the group feels, but it was we had been tracking this case, and June 15th was like, whoa, this happened today. And it was a celebratory moment for sure. The decision was 6-3, and the majority opinion was written by Justice Neil Gorsuch, which is interesting. Trump appointee and a textualist, as he self-identifies on the court. So that was very, very interesting. Dissents were written by Justices Alito and Kavanaugh. Justice Clarence Thomas joined in with Justice Alito's dissent as well. These were some of the pictures that I guess just really, I think, speak a lot of words from October 8th, October 8th, 2019, the day that the Supreme Court was hearing the oral arguments on the Bostock case. And so I wanted to include them. And it like kind of looks like such a different time in some ways, but I don't know, they just bring a lot of joy knowing that this was going on outside the Supreme Court and the decision that was made. So I'll get into some more of the facts behind this case. Gerald Bostock, who identified as a gay man, had been working for Clay County, Georgia, in a role with their child welfare services. He served as a child welfare coordinator, and he had been working with Clay County for a little over 10 years, and every single evaluation and performance review was extremely positive. He received accolades and overall was very much considered a standout employee, according to every record that existed on him, and those who even came out and spoke to that fact as well. In 2013, Mr. Bostock had began participating in a gay recreational softball league. And shortly thereafter, he had started to receive criticism from his participation in the league and for his sexual orientation and identity generally in his workplace. And in fact, when he was in a meeting where his supervisor was present, there was at least one individual that had made openly disparaging remarks about his Mr. Bostock's sexual orientation and his participation in the gay softball league. Though the Supreme Court isn't here to work out all of the distinctions here, from what I've understood, there was nothing that was done internally, that all the comments were let go. There wasn't punishment for comments. There weren't meetings, there weren't verbal warnings, etc., against anyone who had made a comment, although it does focus on the fact that there was one individual who had openly made these remarks. It was right around the same time after Mr. Bostock, who I believe had been, just an average human. I'm always hearing about my employees who are participating in their softball leagues, and whatever, great, your team won, wonderful. But it's very interesting to me in this case that around that time, Clayton County, sorry if I said Clay County, by the way, sorry, Clay County in Minnesota. Clayton County informed Mr. Bostock that they'd be conducting an internal audit suddenly of the program funds that he managed. There had been no background to him having any issues. There'd been nothing on the record of him ever having an issue with program funds that he had managed, nothing. And then you can read this yourself, but shortly afterwards, Clayton County terminated Bostock allegedly for conduct unbecoming of its employees, without really much further explanation than that. And they didn't violate anything under Georgia law by terminating in such a way. So it was just within months, he made a timely charge of discrimination with the Equal Employment Opportunity Commission, EEOC, who also happens to be a partner of North Dakota Labor and Human Rights. We contract every year with the EEOC. So for those who have either requested specifically to have their charges go to EEOC, that's who we would send them to. Sometimes the EEOC has charges that are directly within our jurisdiction, and then we will agree to take those on and split the work, etc. I'm trying to think of some other scenarios where we might work in partnership with them. There's a number of different scenarios. Let me come back to that. I wasn't planning to get into a whole EEOC conversation there. But anyway, remember this timeline. So this was all happening in 2013, where Mr. Bostock experienced what he had charged as discrimination. It wasn't until 3 years later that he'd gone through the EEOC process, et cetera. 2016, he filed a pro se lawsuit, one that he filed on his own without his own attorneys. So pro se stands for is to represent oneself, against the county, alleging discrimination based on sexual orientation in violation of Title VII. So the jurisdictional history of it was that the district court had dismissed his lawsuit for failure to state a claim, and that his claim relied on the interpretation of Title VII, contrary to a 1979 decision holding otherwise, and had been affirmed in the 11th Circuit that sexual orientation was not included in Title VII. Bostock then appealed, and the U.S. Court of Appeals for the 11th Circuit affirmed the lower court. There was a number of other things that were going on at the same time in a number of other circuits. And without having to get too deep into all of the legalese of it, when the Supreme Court actually granted certiorari for this case, they were looking at actually a couple of different cases to try to settle questions in a couple of different circuit courts. So the question that was presented to the Supreme Court: does Title VII of the Civil Rights Act of 1964, which prohibits against employment discrimination because of an employee's race, color, religion, sex, or origin, or national origin, encompass discrimination based on an individual's sexual orientation? With this question, I put this part at the bottom in asterisk to just give a little bit more of information behind Gorsuch's majority opinion, which was that the thought behind the majority opinion was, though there's little doubt that the people who drafted this law in 1964 did not believe they were enacting a ban on LGBTQ plus discrimination, although, you know, that was written, but that might have been a part of it. The thrust of Gorsuch's opinion is that the expectations of lawmakers in 1964 simply do not apply. A pretty bold opinion to write, especially given everything that we know about Gorsuch and his political leanings, etc. So the conclusion was that Title VII does prohibit an employer from discriminating against an individual on the basis of sexual orientation. The opinion went even further. That was the general conclusion, but it went further into gender identity as well. It was a 6-3 decision. Again, the majority opinion given by Neil Gorsuch, with the wonderful and incomparable Justice Ginsburg, may she rest in peace, Justice Breyer, Justice Sotomayor, Justice Kagan, and Chief Justice Roberts, all in agreement with that opinion. So I had mentioned this a little bit earlier, but with Gorsuch being such a vocal proponent of textualism, theory in legal writing and opinions, that the belief that the meaning of a law turns on its words alone, not on the intentions of the law's drafters, was very interesting, because he was actually able to write a very short and succinct and quite easy to read Supreme Court opinion. One of the more upfront opinions that I've read in quite a while. And so this opinion really did, I'm not trying to make this look into Justice Neil Gorsuch, but it is very interesting to look at how this opinion in this case pushed Gorsuch in a way to have to decide between his own politics and following the broad language of this landmark civil rights law. He didn't simply just honor his textualist approach. He wrote the opinion based on the fact that he felt that that the broad language was appropriate for this case. And what his opinion was that only the text of Title VII matters. That's, part of his textualism. So, as Bostock explains, I guess I wrote here at length, but it's not lengthy, that text clearly prohibits employment discrimination on the basis of sexual orientation or gender identity. So Gorsuch lays out why in just these 5 crisp sentences on the first page of his majority opinion. So these were his examples. I'm going to read them directly. I don't like to read directly. I'm doing that a little bit more with this one. I like to do that more when I'm talking about a Supreme Court case, United States Supreme Court case, just so I'm not going outside of the lines of that. So here was his statement, just right at the beginning. In Title VII, Congress outlawed discrimination in the workplace on the basis of race, color, religion, sex, or national origin. Today, we must decide whether an employer can fire someone simply for being homosexual or transgender. The answer is clear. An employer who fires an individual for being homosexual or transgender fires that person for traits or actions that would not have questioned in members of a different sex. Sex plays a necessary and undistinguishable role in the decision, exactly what Title VII forbids. I was going to say this more towards the end, but that opinion, that written opinion, just right off the bat at the beginning of this opinion of the United States Supreme Court is, again, unique and one of the strongest that I've seen, coming from Justice Gorsuch and with his textualism and everything else. I'm trying to refrain from saying certain things, but he made it pretty abundantly clear in this opinion. Even saying the answer is clear, and I think that will be very interesting in the future if anyone should challenge any of this. I'll get to that at the end of all of this presentation. So in the opinion, the main thesis was looking at the terms in quotes because of ellipses sex. And as the opinion explains, this means that if an employer intentionally relies in part on an individual employee's sex when deciding to discharge the employee, or if changing the employee's sex would have yielded a different choice by the employer, then Title VII has been violated. And here are two examples that were made by the opinion. Again, I apologize. I'm not a fan of reading directly, but I do want to read these, having picked these out from the opinion itself. These were made by the opinion in Bostock. So the first one was, consider for an example an employer with two employees, both of whom are attracted to men. The two individuals are, to the employer's mind, materially identical in all respects, except that one is a man and the other is a woman. If the employer fires the male employee for no reason other than the fact that he is attracted to men, the employer discriminates against him for traits or actions it tolerates in his female colleague. So in other words, if an employer permits its female employees to have sexual and romantic attractions to men, but denies that same right to male employees, it has engaged in sexual discrimination, is what this court is saying. It's treating men differently than women. I do acknowledge that this court opinion is limited in some ways. There were some parts in these examples, specifically this one, but I'll get to the next one, where only men and women are referred to. In the second example that was made in this opinion, it was stated, or take an employer who fires a transgender person who was identified as a male at birth, but who now identifies as a female. If the employer retains an otherwise identical employee who was identified as female at birth, the employer intentionally penalizes a person identified as male at birth for traits or actions that it tolerates in an employee identified as female at birth. Again, the individual employee's sex plays an unmistakable and impermissible role in the discharge decision. If someone would have told me that Justice Neil Gorsuch was going to write this, and that his fellow justices who were in agreement with this opinion, if someone had told me that, I don't know. I honestly would have thought that maybe I was losing it a little bit. The conclusions that we see and read and know to be true from Bostock is that the opinion turns on a simple application of Title VII's text. Discrimination, the most important part of this, because of sex, occurs whenever an employer treats male employees differently than female employees or vice versa. And I'm so glad that this was included, because to me, if that was all it was opined, it's good, but it wouldn't have brought everything into the mix. It probably still doesn't, but it helps a lot. And because discrimination on the basis of sexual orientation or gender identity necessarily requires an employer to treat some male employees differently than some female employees or vice versa, such discrimination is illegal. That was also keeping in mind the examples used for those identifying as transgender, male or female, or otherwise. Final conclusions here. The text of the law was the only thing that mattered in the Bostock opinion, as was written by the majority opinion. As Gorsuch had concluded in his opinion, ours is a society of written laws, and that means that judges are not free to overlook plain statutory commands on the strength of nothing more than suppositions about intentions or guesswork about expectations. And because Congress adopted broad language making it illegal for an employer to rely on an employee's sex when deciding to fire that employee, the court must hold that anti-LGBTQ discrimination in the workplace is illegal. I want to give a pretty just straightforward presentation on this today, but in between every single word that's written here, I think that there's much to be said about maybe what even the Supreme Court was saying about a different branch of government, that of the legislative branch. And how the Supreme Court, our judicial branch and legislative branch, should, or I guess should in this case, should be looking at one another according to the opinion. Here's one thing that's really important to note, because this was a tremendous opinion, obviously. I think that we can put this in like we can in federal Indian law, which I talked a little bit about just for a second over the noon break, of how it interfaces with everything. But without certain case law, federal Indian law wouldn't exist. And I think what we've had specifically in the last 10 years, marriage equality, this case, and I know that there's going to be more. I think what we're seeing shape up is something very strong. Federal Indian law, the Marshall Trilogy, when Chief Justice Marshall had made 3 opinions back in the 1800s that has been described as the creation of Indian law. Those opinions, though they've been shepherdized over and over and again, and it's, most of it really doesn't, well, some of it exists still in law, it still is always looked at as the creation of Indian law, and is still always referred to language within there, such as tribal nations being domestic dependent nations, which is all, none of that, those 3 words together don't make sense. I'll wrap this in here. I promise I'm going to go back here, but I want to just make note that we're still talking about the Marshall Trilogy today. I talk about it daily. And I think that we're going to be speaking about Bostock for a very long time. I will be getting into some things, and maybe there will be questions about how this will all look going forward, etc. Sorry, I just wanted to check on my time, 1:39, okay. But nevertheless, this was huge. Okay. So I'd be remiss if I didn't mention this next part. Anti-LGBTQ plus employers may still gain a religious exemption to Title VII. What I mean by that is, and I'm going to go pretty literally off of this because I'm still kind of figuring this out for myself too. So, okay, we can agree, particularly in this group, that Bostock was obviously a major victory. Before Bostock, it was still legal for employers to discriminate on the basis of sexual orientation or gender in most states. Okay. But it's still unclear whether Bostock will entirely ban workplace discrimination on the basis of sexual orientation or gender identity. The United States Supreme Court is also considering whether to grant employers with religious objections to LGBTQ plus people an exemption from anti-discrimination laws. And very honestly, if the question came up, do you know, Erica, when that might be something that is given by the Supreme Court? How will that change now with the passing of Justice Ruth Bader Ginsburg? I don't have answers for that. I just don't. I think that there's a lot of very intelligent legal minds, far more intelligent than I, that could probably surmise different thoughts, interpretations, etc. But I don't know if any of us really could have an answer on that. In a concurring opinion in something that I think everyone here knows about, the opinion in Masterpiece Cake Shop versus Colorado Civil Rights Commission, the 2018 case that had quite a bit of publicity around it, rightfully so. Gorsuch suggested that religious conservatives should enjoy sweeping exemptions from laws prohibiting discrimination on the basis of sexual orientation or gender identity. This is as close to the time as, but we're in fall right now, and I still have the language. The Supreme Court is expected to hear a case next fall. We're in fall right now, and so honestly, I'm not even going to change this. We could be looking at next fall at this point because there's just so many question marks. But nevertheless, the Supreme Court is expected to hear a case asking whether religious organizations have a broad right to engage in anti-LGBTQ plus discrimination. And Gorsuch's suggestions that I just had stated above there are disconcerting, to say the extreme least. So looking at the future, the fate of individual LGBTQ workers remains unclear, at least for employees with bosses who object to LGBTQ people on religious grounds. And that's where I see focus work already happening. But if I could really just drill down on just the Bostock opinion and next steps, these would be next steps as I would see for them to be a big push for those who are trying to make sure that that an opinion doesn't come down for anti-LGBTQ plus discrimination on religious grounds, which has always been up in the air. It's been something that I think all of us have thought about for a long time, but now more than ever with the Bostock opinion, it's certainly important. Oopsies. So the North Dakota Department of Labor and Human Rights interpretation of Bostock. I think I made it pretty clear by saying that this was exciting and wonderful and historic and everything else, and how, et cetera, that our department was extremely happy to grant, I don't know if that's the best word, but that's the word that has been used, full application of the Bostock opinion in both of our divisions of both labor and human rights, which is very different, by the way, comparatively to some of the other 25 other states outside of ours in how they interpreted this, because this is an opinion by SCOTUS that is directly based on employment. However, we were able to see, just in reading our North Dakota Human Rights Act, that we could apply it to both labor and human rights. So we had made this statement that it was the department's opinion that the Bostock definition of sex may and should be applied to the North Dakota Human Rights Act as amended and the Housing Discrimination Act as amended. And so on effective June 15th, 2020, the department began accepting and investigating complaints of discrimination based on sexual orientation and gender identity in all human rights laws the department enforces, which includes employment, public services, public accommodations, credit transactions, and housing. And the department is in the process of still updating our intake forms and education material to reflect this decision. I think that for the most part, we've had most everything updated I think our educational material is kind of always in flux in general, so that might be the only place where we would still be updating. But we've already had, I mean, it was very interesting to, I use the word interesting, that's such a North Dakota thing, or maybe my family thing. Interesting can mean so many different things. When I say interesting, I mean amazing and cool. That it was so neat to get informed from our intake specialist that the day that we received our first complaint, and the fact that we didn't have to say no to it, and congratulating the investigator who was working on it, for her work that she was doing on it. I'll never forget those moments. So try not to cry. This will help me not cry. Future considerations. Numerosity has been addressed. Oh, one thing I should say, I said it, I hope it was clear enough, but when I talked about the fact that there's 25 other states that now this opinion is the law of the land for, this changed 26 different states in how we must enforce this law. Like I had said, ours, we were able to apply it to human rights, housing, everything under human rights and labor. For many other states, if you happen to work or live or have relatives or whatever the case is, in some states where they could only enforce it, or maybe kind of even like one of those things where it was like, oh, we have to enforce it in employment or celebration. And you're surprised, or whatever the case is, that their housing rights, human rights in general, it hasn't been applicable to. That was because of the way that our Human Rights Act was written. There was like a couple of little words in our Human Rights Act of how we could apply it to both. And we ran it by numerous attorneys, advisors, et cetera, to not only our agency, but people outside the agency, where sometimes we have to take questions to, and unanimously it was held that we could take those cases in both areas. Numerosity came up just briefly by an attorney who had approached our agency, and I actually need to pull up some information from, I was trying to look up some other states here. Dang it, sorry everyone, I should have had that right on me. I'll just speak then to what's directly here. Numerosity at the federal level, Title VII, which is federal law, we've been talking about it this entire time, that applies to U.S. employers with 15 or more employees. It's very important to note, it does not speak to state anti-discrimination laws, which importantly often apply to employers with less than 15 employees that would not be subject to the federal law. As a practical matter, however, based on the Supreme Court's decision, most employees nationwide are now legally protected from sexual orientation and gender identity discrimination under federal law. In North Dakota, numerosity really didn't have an effect in a way where we felt so concerned. Oh, great question, Michelle. I'll get to that here. Okay. Oh, no. Did I end my slideshow? Oh, okay. In North Dakota, under our state's anti-discrimination laws, these laws apply to an employer with one or more employees because of the fact that, our businesses, by their very nature, are by and large small businesses, and that was, of course, state law. So when people ask me on what's going to happen, how is this going to be, how could it potentially be, I don't know what the right word is to use, I guess, messed with, maybe. That's not the exact word that I would like to use, but it's the word that I am using. I'm treading a fine line here, as always, with the neutral part, but also just the human part of all of this and what I think is right to say. The way that I view this, which could potentially not be right, so I'll preface it with that, is that if there were groups of people or anyone else that wanted to see this change in North Dakota to make it harder, this numerosity element, for how anti-discrimination applies in North Dakota, if one sole reason for changing the number of employees to be considered an employer, I mean, they'd be taking down small business in North Dakota, which, bold statement to say, I don't know, the truth, probably. So I'd have a hard time seeing that go over well. And I haven't heard of anyone even suggesting that at this point. But I've been asked this many times, so I'm bringing it up. Some other future considerations that I'd just like to make, if you're in any role in this as a ally to people experiencing discrimination, as someone who potentially you are an employer or you are an employee in any of these scenarios, the best practice for compliance with this law is making sure that your employer, or as an employee, that your handbooks, your employee guidance and employee handbooks are updated to reflect everything that this law now allows. And you can push your employers to have that. As an employer, update your handbooks immediately. And if you are aware of groups that are not doing so, I don't think it's at a point where, I don't know how to say this the best way. I would say this, as much as you can do to help update employee and employer handbooks across the state, that's wonderful. And that would be the advice of the Department of Labor and Human Rights. That's the advice that we always give when there's updates to the laws. There's going to be some practical impacts of this decision for workplace practices, which already existed, but certainly with this decision, it may or may not come back up, and there might be new considerations as well on things that we have heard at this point many, many times: gender-based bathrooms and locker rooms, dress codes. I think out of everything, dress codes has come up to me the most, where employers had reached out to me, and some employees had reached out to me as well, about how this might affect their dress code. And the opinion of the department was, the Bostock opinion doesn't change anything necessarily about your dress code, it does need to be inclusive. So if you have a non-inclusive dress code, then you need to rework, and you should have already reworked that anyway. There's also some practical impacts in areas such as public accommodations, service providers, and retail. This isn't the end by any means. And I'm totally preaching to the choir, I know that. And I believe it was Justice Alito's opinion, which was pretty rife with homophobia, transphobia, amongst many other pretty ugly things. The justice did make some points about the fact that it would have broad impacts, which I think he wrote in a way that was fearful. I guess in for our discussion today, I think it's a good thing that it could have such broad impacts in all of these different areas of law. Can anyone still see my screen, by the way? No? Okay. I meant to take it down, but I was going to try to find, I'll try to send out some links here too. These, I was able to just, these were just articles that I've been reading since the opinion came out. I'll put one of the ones that I thought was very helpful in the chat about its broad implications. So one can read more about that there, but I think that to me, I see on the optimistic end of things, I see this opinion being able to, like we were talking about over the noon break, be an area where we see that this opinion does interface with so many other areas that we desperately need equity, equality, inclusiveness in. That was the end of my presentation. I just wanted to say thank you so much again. And I don't know, Alex, how you wanted to do this, if we had time for conversation or not. I know I went right up to 2 o'clock. So I'm happy to speak further at any time. I didn't put my information, I'll put it in the chat. And I'll put our main line at Department of Labor and Human Rights as well in the chat. But I really wanted to say thank you to everyone for your kind attention, and thank you again for asking me to be a part of this. I'm sincerely grateful for it. Thank you.
Thank you, Erica. It was very informative. I learned a lot because I tried to read up on it, and you actually explained it in a way that I understood it better. So thank you.
You're welcome.
If you want, there are 2 questions. If you did want to answer them, we do have a little bit of time. We could answer those 2 questions if you'd like.
Absolutely. Yes.
There's one.
Okay.
Michelle. Oh.
Yep. So Michelle, hi, Michelle. She had asked, do you know if HUD applying the Bostock decision to their housing complaints? This has been up in the air. HUD is also another partner of ours. And when I say that, I mean that we are in contract with them. We consider it a partnership. Short answer is to be continued, and I don't think that there is a real answer yet. In my conversations with the folks from HUD that I'm able to speak with, this hasn't been a huge consideration for their work at this time. They had a pretty narrow opinion on the Bostock opinion, that it solely applied to employment, and that our partners at the EEOC were accepting complaints based on it. So that might be a place for anyone interested, et cetera, to maybe start looking into ways of reaching out to HUD or learning more about its application. And I certainly know that there's other states that are applying it to their human rights, even prior to Bostock. It was a part of their anti-discrimination laws. Faye, hi Faye. How will this impact the interpretation of title? I'm sorry, I can't see that. Protections or specifically queer student. Oh, okay. Great question. Sorry for the pause. Great question. I think it's, I don't want to give the wrong opinion on this. So I welcome anyone else who might have an interpretation, et cetera. Again, thus far since June, Bostock has been narrowly interpreted by most entities, and in protections primarily for employment discrimination. That was the last question, I think. So I apologize, Faye. I don't know if I have a real answer, but I would love to hear from anyone else if they've had more information or insight on that question. Yeah, I have to admit that I'm not really, my roles that I have in my department, it's a little bit out of my jurisdiction, particularly education. Okay, Faye, another question. With Gavin Grimm, the answer seems to be maybe. In general, where should people go who do have a complaint? Faye, are you speaking to Title IX and where people should go with the complaint? Title VII. For complaints for students. Am I understanding that right, under Title VII? Oh, okay. All right, for employment. Yeah, I mean, I would encourage anyone, you may go directly to the Department of Labor and Human Rights here in North Dakota to be able to file a complaint. You may also go to the EEOC, Equal Employment Opportunity Commission. Depending on what, I'm trying to think. I would certainly suggest those two. I was going to go into a whole nother thing and I realized that it's not applicable. You know, here's one thing that I forgot to mention, but I wrote down in my notes. One thing that kind of is frustrating, and just on a personal note, and kind of drives a little bit of some of the emotion that I can't always speak about because we are a neutral law enforcement agency, but I feel that the commissioner should be allowed to speak in that way. There's nothing statutorily to say otherwise, that I have to remain one way or the other. And every commissioner before me has chosen different paths for themselves. When filing a complaint, I'm just going to be very honest, it can be very difficult to get a for-cause finding. And the main reasons why at times our agency, through our investigators, and then directly goes to our human rights director, and then I get my eyes on it at all sorts of different parts throughout the claim. The main thing that we see when we can't push it through, I'll say, where we can't make a decision for cause or merit, is that there were no witnesses, which is extremely frustrating in the process that we have to follow, because we all know that oftentimes there aren't always witnesses to these things, or if there are, they don't want to speak. And we do have the power now at this point, the Department of Labor and Human Rights, to subpoena witnesses who are crucial. That came about 2 sessions ago. Luckily, that was a long-standing thing for our agency that was an issue. But even then, there was a case unrelated to what we're talking about right now, but under anti-discrimination, where the witness moved out of the jurisdiction that we live in, and actually moved on to a reservation on a state outside of North Dakota, and rendered us completely unable to subpoena. And though that's not always a scenario, there are other scenarios like it that can come up. And so we have to respect the jurisdiction of others, et cetera. So witnesses are important, but I also understand that that's a very tough thing at times, to have a witness who will be willing to speak on your behalf or tell the truth, quite frankly, of what happened or what they saw, because of fear and probably lack of education, where we're still having to push as a department that whistleblower laws include those who are speaking as witnesses. You're protected to be able to say these things. If you're fired because you were a witness who said Erica was discriminated against because of her sexual orientation, you cannot be fired. And if you are, then you yourself have a claim. So what I say for anyone is document everything. And this group is so incredibly brilliant. I know that you all know that. If you know people who are in these scenarios and you can give advice, I would say more than anything, make sure that you can document as much as possible. We live in a one-party consent state when it comes to recording, et cetera. Take as much notes as you can as soon as you feel that something is off. Work as much as you can, and I know that it can be so tough. I know, and I also don't know too. There's a lot that I don't know about it as well, because I haven't had that lived experience, but sometimes I have. Anyway, I hope you understand what I mean when I say that. I haven't had the same lived experience as all of you and others, but I have had some experience where I've had to work very hard at trying to suggest that internal policies be changed. And I think that if anything, you're protected by law, and you can prove that. And there are great groups out there, advocacy groups, et cetera. We aren't one of those. That's another tricky part with my agency, this neutral law enforcement agency thing. A lot of people have heard my pains on it before. It has a purpose, but it also kind of takes away from what I think some of the work that we could be doing. It takes away from us being able to do it, which is why I've felt that the commissioner doesn't always have to fall in line with such a strict role. The law also says so. I just want to make that clear. Okay, so I'm sorry, Faye, I was really all over the place. I hope that that answer kind of made sense as far as what things should be done, and where you can make complaints. And if the complaint does not come out with cause or merit, I'll say this on behalf of the Department of Labor and Human Rights. Certainly our process and procedure, we are very limited in how we have to look through all of the elements. Some of the main ones being witnesses and evidence. And if we don't have those things, we really are in a bad place to be able to make a cause finding or a finding of merit. Okay, I'm sorry if I'm taking up too much time here. I just see one last thing. The worry is that colleges receive Fed funds, so they have to adhere for faculty and students, but there are also religious schools that apparently do not receive federal funding, but also rely on student loans, federal loans. So again, to be continued. Would agree with that conclusion of to be continued. You know, I think it's probably a great point in time to work with colleges that you might have a connection with, our tribal colleges, it'd be very interesting actually to speak with tribal college leaders on this subject because of the jurisdictional differences. But having maybe spoken to some leadership amongst tribal colleges, there's interest in this. Anyway, okay, I need to stay on point of the jurisdiction that I can talk about. I think it's a extremely important time to reach out to like NDUS and the chancellor and whomever leadership there is at, or whatever leadership there is, that kind of sounds bad, the leadership that exists at our colleges here in North Dakota. I think it's the perfect time. So yeah, go forth and know that that this opinion is the wind behind your back for sure.